So this is a really small group, which means that I am totally accessible to interruptions and questions at any point, or even stories that you want to tell, because that'll make this go faster. My name is Attorney Andrea Burton. I am a staff attorney at Community Legal Aid. I primarily practice in Youngstown area, so Mahoning and Columbiana counties, with some overlap in Trumbull and Portage County. This presentation is on survivors of domestic violence and legislative updates about intimate partner violence that are upcoming, and some statuses or trends and laws that we currently see. So I've been practicing with legal aid for about 2 years. I have been a practicing attorney in general for almost 8 years. And prior to coming to legal aid and dedicating my professional career to survivors of domestic violence, I was a criminal defense attorney practicing misdemeanors all the way up to felony of the second degree. And I was just beginning my certification in death penalty cases and murder offenses when I jumped ship. So I have a wide range of experiences. As a litigator with legal aid, I handle about 3 or 4 trials a week, evidentiary hearings related to custody and family law disputes, including protection orders. I'm also involved on the statewide coalition in terms of making sure that there are common sense legislative acts or statutes being presented and passed by our legislators that affect domestic violence victims and their access not only to civil but criminal justice in terms of being victims and prosecutorial things of that nature. And just recently I've joined the OSB, the Ohio State Bar Association's Leadership Academy. So I'm one of their upcoming students for this year, ending in June 2020 is when our final class is. So that being said, I'm going to begin with the presentation. There is a lot of law, but I don't try to teach the law the way law school would try to teach it. It's to be accessible for you to understand it, to know where resources are out there, and in terms of like practical implications on real life people and not just statutes, which, you know, that doesn't make sense to most people. I have some brochures in the back that detail sexual assault victims and stalking, domestic violence victims, dating violence, and safety plans for those who are in intimate partner relationships that are violent and volatile, things that you may need when you attempt to escape, and other resources, as well as my card back there. And I am open, as I said, to questions now, or if you want to ask later, I'm totally fine with that. If you need to go and get more to eat or drink, don't feel rude, go and do it. Please, by all means, especially with this being such a small class. So I prepared this presentation with my coworker, same staff attorney with legal aid, handling domestic violence cases, predominantly with Stark and Medina County. Her name is Caitlin Benzo. So you'll see some of her slides in here as well as mine. So what is legal aid? We're a non-for-profit organization. We serve elderly and low-income clients in 8 counties. We're federally funded, though we do have some state fundings. This year, we received a large endowment from the state legislators, dedicating about $1 million to legal aid, which has been the first time in a significant amount of years that the state has directly given us money. So $500,000 of that is to go to families suffering from the opioid addiction, and $500,000 of that is to go to veterans. So how does that affect what I do? Not very much, to be quite honest. Those are categories of people that traditionally already have a great deal of funding. So outside of that, we service people in areas of family, housing, consumer. In consumer, I mean debt collection, bankruptcy, education. And by that, I mean IEP, special accommodations for children with disabilities and their parents. Immigration, we have a very hefty clinic in terms of only having 1 lawyer to service 8 counties in immigration. So her caseload is very, very heavy, as the time period would make you think it's only increasing. Public benefits in terms of denials for SNAP or SSI or SSD. We have a employment opportunity clinic where we try to help veterans or people who have recently been incarcerated from prison, helping them find housing and jobs and stability, so not to return. And our most recent clinics are record sealing, which have record-breaking numbers in Mahoning County, for most of the reason being that there are low-level theft offenses. Sometimes we help with driver's license reinstatement programs, which is a hefty problem Ohio ranks high on the list of driving under suspension drivers on the road who are incapable of getting a license back for a variety of reasons, whether it's child support or whether it is because they don't have insurance or cannot provide insurance for themselves. We provide clinics to people who want to learn how to self-represent, and that includes in divorces, but those are not contested divorces. There's generally no property and there are no children. So in order to be staffed as with me, you have to be a victim of pretty severe violence. You have to have children involved typically. We do give priority to same-sex couples because we see a lot of issues in terms of access to justice with those couples. And typically there may even be a pension involved, which involves a specialty that we actually, just service out to an expert in pensions and dividing them. And that's very important because if it doesn't get it right, you didn't get your retirement. So we do fix other people's mistakes too, in terms of someone not correctly filing a pension. You would come to me and we'd hire an expert to make sure it's done and file it in the court and make sure that you start to get your pension, which is also a huge problem with veterans. The family is a family team. As I indicated, we're dedicated to assisting victims of domestic violence, intimate partner violence. Sometimes we'll do a few stalking cases, and I will differentiate between stalking and domestic violence, but sometimes people fall in unique categories, so they don't fit in one category or the other. So we have to make them fit into something in order for them to prevail in terms of getting protection. So stalking cases are generally what you would not think. They're not a stranger who is harassing you by calling and texting you. Typically, our stalking cases are neighbor disputes. Neighbors don't get along about a tree. Their kids are on the lawn and behavior escalates. And so they seek help from the General Division of a Common Pleas Court. And depending on their age, specifically elderlies, regardless of income, typically, we are obligated to help under our federal providers. Those are the cases that we commonly have. Now, there has been an increase in domestic violence protection orders with elderly people. And that's usually tailored to the fact that there is an opiate crisis. And so adult children are returning home and stealing and abusing from their parents. So that's the most common way in which we see protection orders with elderly people. So as I said, we are federally funded by VOCA and VAWA. So there are certain things or cases we can't do. We can't get involved in criminal cases. We can't lobby. We can offer facts. We can offer and explain how certain legislation may affect the people that we service, but we can't say we're for or against a specific act. We can't help a minor acquire an abortion. I mean, they're just things that the federal government prioritizes, and when they give us funding, we can't. Most recently into next year, the federal government has decided that legal aids are going to be cut by 70%. So that's 70% of our $1 million budget, which is gone, which means that people are not going to be serviced. They're going to have to navigate the system entirely on their own, as cumbersome of it as it may be. And some of these people are victims. They cannot read or write, so one of the ways we try to replace that is through literally crowdsourcing, having private organizations fund us by giving us money. So within the state of Ohio, community legal aids in Cleveland, because there are major firms there, they get millions of dollars in contributions to help them fund some of the work that otherwise would not occur. So what is domestic violence? Does anyone have any experience with seeing it, witnessing it in their professional career with family or friends, so they have a basic understanding of what domestic violence is?
Basically, family.
Yeah. So legally, that's exactly right. Legally, this is the definition of domestic violence. It's a household member or family member related by law, blood, and in order for you to fit into the domestic violence statute, let's say your brother was abusing you, you'd have to have lived with your brother at some point in your life. Now that sounds simple, but you'd be surprised with people living longer and fertility rates sometimes being better. People will have kids that are maybe 20 years apart. And so by the time a younger child is born, they've actually never lived with a sibling. So they wouldn't fit under the domestic violence statute, though they're related to that person by blood. For partners who are in an intimate relationship, that means that you've cohabitated, lived with the other person within the past 5 years when that act of violence or physical threat has occurred. So a pattern of assaultive and coercive behavior, including physical, sexual, or psychological against an intimate partner, It may include financial and economic control as well. And usually there are repeated levels and there's an escalation. So I want to preface this with saying something. Ohio is sort of very far behind in understanding what intimate partner violence means. So while I have up here that it can include financial and economic control, it can't solely be that. Ohio doesn't recognize that as coercive behavior on its own. It has to be in conjunction with physical violence or the threat of physical violence. And when we say psychological disturbances, extremely hard to prove. And there actually isn't much consistency between the appellate districts in Ohio. So totally, there are, I believe, 12 appellate districts within the state of Ohio, and each of them has their own opinion on what psychological harm means. So depending on what district you're in, that will determine your access to a protection order. Where I practice in the 7th district, it used to be a very stringent standard, but it has lowered since. So the stringent standard used to be just as early as the late 1990s that you had to receive some type of psychological treatment, be under the guise and treatment of a psychiatrist. But how many poor people actually have access to psychological treatment? So they wouldn't necessarily be fit under that criterion of psychological damage. Now it just says, through your common experience, what has changed about your existence? Are you no longer going out with friends? Are you finding it hard to sleep? Do you only ever want to sleep? Are you afraid to go out? Do you constantly watch over your back? These are standards of domestic violence that we see, that we commonly know that someone may experience if they're being abused. And so now that's the standard. So if you testify that these are changes that have occurred in your existence and that you're frightened and a reasonable person would be frightened, then a court in the 7th district and in the 11th district would be able to grant you a protection order on the basis of psychological harm. Okay? So domestic violence is a special relationship. So people don't have to be attacked physically. They can be psychologically harmed and they can be stalked. But there is a separate order for a stalking order, which we discussed just a moment before. But we're not so much concerned with the title of the protection order, but the nature of the relationship. That's where you always start. So you can be a victim of domestic violence, but you're really experiencing stalking, a pattern of conduct. And so you would still qualify under the domestic violence stalking order, even though there is a separate order for stalking. And that is just because we reserve stalking for, again, people who don't have special relationships, like the neighbor or the stranger stalking someone. And in the past, it used to be someone that you may have dated, but you never lived together, you didn't have any children together. But maybe you went on 2 dates and the person just would not leave you alone. They constantly harassed you on social media, they drove past your house, they showed up at your job. Only until 2018 did Ohio have an actual protection order dedicated to those situations where people were just dating and had not lived together, had no children. That made us 49th in the entire country. And these are the type of trends that we commonly see, that we're very far behind in understanding and appropriating and reacting to domestic violence. So sometimes the high risk I walk around just to let you know, it's easier that way, and then you're not focused because it's the least dynamic. So domestic violence usually has the most dangerous period of time within the 18 months of leaving. So you've separated from your abuser. You imagine that you're safe. You're not going to see them anymore. They can't control what you do. And then within that 18 months, that's the most dangerous period of time for a person leaving a violent situation. You're more likely to be murdered within that 18 months. I don't mean simply attacked, I mean literally murdered. So access to weapons is also a predictor, of course, of the likelihood of domestic violence. And sometimes it isn't even pointing it at you or threatening with you. We had a case where a gentleman had tons of weapons, but he specifically would put a 9mm bullet on the table when he was upset with his wife. Never said anything to her, but she knew what the implication was. And he understood that she loved their pets. He would beat the dog with the butt of his gun in an effort to control her. Now, obviously that's illegal. That's a felony. So in some ways we see the laws that protect animals being greater than the laws that protect human beings. But you would think of that as coercive. That would frighten you to see a 9mm bullet on your dining room table after you had just had an argument. And certainly a dog or pet that you loved being brutally beaten would send a message to you, even though you weren't directly threatened with it, right? That's an agreement. That's disturbing behavior. Drug or alcohol abuse, as I mentioned, opiate addiction, that's always a fueling or factor. Sometimes when we see elderly people being abused, sometimes there's issues with dementia, failing health. It is never an indicator that the stress of being a caregiver is a reason for domestic violence. There are tons of people who are caregivers who will never beat their elderly parents or relatives. That is something, a manipulative tactic used to explain a situation which otherwise has no excuse. And so commonly we hear things like, well, if you didn't do this, if you didn't talk to me this way, if you just knew how much I loved you, I wouldn't have to do this. That's not a predictor either. There's no behavior in a relationship, including cheating, which would ever legally justify someone attacking or otherwise harassing you. You have to be an adult. Leave the situation. No one is making you stay in it. So if she's cheating, he or she, then you can't blame it on that behavior. It's more about your desire to inflict pain than it is about the behavior that they've committed. So strangulation is a huge factor, and that's because the signs are not always present. We see shows like CSI or Law and Order, and any number of shows where we see strangulation and we see marks around someone's neck the size of handprints. It's not always that way. In fact, if a person is skilled in strangling someone, they'll leave no outside marks. And the darker you are, the less likely you are to have marks on your body. And it is fatal precisely because cutting off oxygen to the brain usually creates aneurysms that later explode, whether it's months or 10 years later. There's a case in Ohio which is leading the entire country in terms of knowing the lethality of strangulation. A woman was attacked by her husband, strangled with the kids in the house after she had separated, and he had showed up repeatedly with guns and the police never arrested him. He broke into her house and strangled her, and she lived a normal life. And 10 years later, she had an aortic tear, which essentially ruptured, and she died, and he was charged with murder. So strangulation is one of those things where we say, if it's happened, you really should go get medical attention, because the only way which will confirm this is, as you can imagine, an MRI or a CT scan. And strangulation, again, is also high on our lethality assessment, and I'll explain what that means, precisely because the person is skilled in hiding it. That you don't know the danger. You can't see the marks. They wore shirts up to here. Perhaps they don't use their hands and they use a towel. It's still during a strangulation. And the signs and symptoms of your body reacting poorly are, excuse my language, you urinate or defecate on yourself, which is a huge indicator, because it says that your basic muscles are losing oxygen and they are dying slowly. So it's going to start managing that by loosening the smaller muscle categories, which is holding your urine in and your feces. So when that happens, when the person says, I started to see SARS, that's your eyes literally dying, the cells that combine them. So we ask these questions like, tell me what's going on. We ask them, strangely, what do you smell? Because the brain is affected traumatically by things that you smell. It smells things that it thinks are chemicals like mercury, but really it's just the brain dying, and that's how it processes it. So these things are very serious. So statewide in 2018, there were 75,000 domestic violence calls, 76,000 domestic dispute calls. So they're arguing there may be no knowledge of whether there was an actual threat or physical violence. The charges were only 38,000. 3,000 resulted in other charges. We consider that assault, maybe disorderly conduct. And 33,000 resulted in no charges. So a common misperception that I hear from law enforcement is, well, if I show up and even if one person has marks and the other person is saying he or she attacked me first, we're going to take you both to jail, which makes no sense. So basically it's a cancel out. Unless you both want to be arrested, then you both need to say, never mind. So if I'm getting my butt beat, but I don't want to go to jail, and maybe I only scratched him because I'm defending myself, then I'm saying, never mind, I don't want to even press charges, it's fine. Because who's going to take care of these kids? What's going to happen to my criminal record? And so those are common problems that we see, and this is why we do record sealing. It's because sometimes the true victim is the person who is charged, even though they're the person who's being attacked, and even though maybe, they responded, and so he or she has marks, but they're not the true victim in this situation.
So what do you do in situations like that? Or what do you tell victims in situations like that? I'm speaking or asking for also myself because I was actually in that situation as
Sure.
a victim.
Right.
And I'm calling for the police and he comes out and, oh, I'm taking both of you to jail. Wait a minute, I called for your help.
Yeah.
Why am I going to jail? So what do you tell victims in certain situations like that?
Please excuse me. It's a very good question. So obviously we're not with you when you call the police, right? It's just you, that officer, and the person who has been abusing you. So you can, of course, say, that's fine, I'll just go talk to the prosecutor. You have a right to go talk to a prosecutor to have charges considered or instigated. But really, that's not a helpful answer to you. So what I say is this. Part of the statewide coalition that I am on is law enforcement enforcing protection orders or respecting the rights of domestic violence victims. So our goal is to educate the officers who have really like maybe 5 hours of training on dealing with domestic violence calls, even though that's the primary thing that they deal with. So domestic violence victims come in all sorts of shapes and sizes and mental capacities and abilities to react. And so understanding that and appreciating that means that you have to just do a little more in-depth investigation when you arrive at a domestic dispute. Number one is you should separate the parties. They shouldn't be shouting over each other. We need to assess the situation to say, you tell me what happened, and then another person is talking to the other guy about what happened, and then the two officers meet to discuss what was relayed to them. They assess the physical prowess of the people involved, which is not always an indicator, because we've had people who are huge get attacked by people who are small because they don't want to be responsible, because they know that if they were to exert any power, the person would be seriously hurt, even though they were defending themselves. So you have a right to talk to a prosecutor in terms of getting charges filed. But I think one of the other things, as I said, educating the police at roll call, which is, right before they go out on the road, what domestic violence look like, that particularly there is a difference. Believe it or not, we've seen it statistically. We know that science breaks this down, and how people of color and how Caucasian people respond to police or domestic violence. So when we talk about that, what that means is that people of color typically react much more stressed out. They're yelling, they're arguing, and there is on the other side this perception that white people are crying. They look like a victim. There's no look like a victim. If you have been a victim, you look like a victim. So one of that is to change those perceptions. We know that because people consider Black and brown people to be more promiscuous, sometimes police think that's a justification for things that happen to them, even if there's equivalency between fidelity between all races. You're more likely to cheat if you're going to cheat. It doesn't matter what your race is. But we give credence to these divisions, these biases that don't actually make sense and they don't bear out with science. And so it's about educating people about that. Now, one of the common things is that, again, when I see people cry, I've had people tell me about horrific things that I can never imagine in my life, totally flat, like they're just telling me about the weather or what they've had for dinner. They have no emotional response to what they're relaying when it's otherwise, I was beat to the point I was in ICU. And what we know about that is that people who live in domestic violence situations, they are under so much stress that they're always in that flight response. That thing that happens to you, that adrenaline after you experience something that's truly shaking, a car accident, or you see someone shot or stabbed, your heart rate increases. Your body essentially goes into flight mode for survival. And sometimes it's freeze. It's not always flight. But when that happens perpetually, your brain gets stuck in that mindset. So nothing outside of it is responding appropriately because it literally cannot. And so when you see that, unless you're trained that perpetual violence in a home changes mentally the chemistry in your brain so you don't react a certain way that you would expect a person who's never encountered this to happen, would make you think that the person was lying. So you're telling me he strangled you, but you're not crying. You don't have any marks. You're still with him. These are things that are not typical. So when you approach it, you have to approach it in an atypical stance. Domestic violence is a different type of crime than you getting robbed by someone on the street. It just doesn't happen that way. So sometimes you have people who are overly emotional. And so sometimes that's a negative. I know you're lying because you're overly emotional. It's not that serious. You have mental health problems. You can't predict how someone's brain is going to respond to something. And we've seen this in children. Children who frequently experience or witness violence, total non-response to it. And they commit acts of violence because they have no emotional way to say that it's not appropriate, it's been happening. And so it seems like there's no remorse, but in fact, it's just trained behavior. There are a lot of psychological studies, just a guy out of Pittsburgh whose entire career is finding out how violence affects kids and how their brains work. And essentially, kids who experience violence die at earlier ages. They have lack of achievement, usually subject to crime. I mean, they have ADHD. They have a higher risk of heart disease. Things that you would never think about because your body not only responds, your mind also responds, but these have an effect on you because the chemicals that your body creates from dealing and anticipating violence, when prolonged, basically are like a cancer that eats away on your insides. That sounds crazy, right? No one thinks about that type of stuff. So what do you think is the most likely way for someone to be killed in a domestic violence situation? You think it's physical prowess, I beat you, I strangle you, or is there a weapon involved? Guns. It's usually a predictor. And so there are some statistics out. So 32% of cases where there was domestic violence with a weapon involved involve suicide. I'm gonna harm you and kill myself. 14 completed homicides/suicides were perpetrated by males against females and 2 females against males. 81 fatalities in 60 cases. 53 deceased victims, 41 of those were victims, 12 were male victims, and 28 deceased perpetrators. In at least 35% of fatality cases, the victim of intimate partner violence had ended the relationship or was in the process of ending it. 35%. 15% of cases involved the entire SWAT team responding because it was a hostage situation. 67 people were killed or injured by guns, July 1st of 2018 through June of 2019. That's just half the year. We're not even through the year yet. 3 cases resulted in Amber Alerts during or prior to the altercation, using the children as a method of control by taking them. 25% involved children at the scene of the crime. 32% of the cases, at least 32% of the cases, the perpetrator had previously been convicted of domestic violence or assault charges. That's staggering. So outside of the criminal justice system, what tools do we have to help victims who are experiencing intimate partner violence? So Ohio is really rare in this little unknown fact, but Ohio is one of the few states where a victim can actually bring charges even if the prosecutor chooses not to bring them. But that has to be in felony cases. The most notable example of this is the Tamir Rice case in Cleveland. The prosecutor had declined to prosecute the officers involved in that. So the community, including community-based attorneys and Tamir Rice's mom, brought the charges on their own. They presented it to the grand jury on their own. That doesn't happen in most in most states. That's not an option. But those, again, are only felonies. And since domestic violence is a misdemeanor, unless it has previously happened and then it becomes a felony, you don't have that as an option. So what do? This is where I come in. So my tools, what I do is primarily civil litigation for intimate partner or domestic violence victims. You can get a protection order. There's domestic violence, which we discussed, dating violence, civil stalking, sexually oriented offense, juvenile protection orders. Temporary protection orders are usually through the criminal process, but every single one of the ones mentioned before, they have a temporary protection order mechanism built into it too. And we'll discuss what that means. And then there are criminal protection orders, as I indicated, which are again through a criminal case, and no contact orders. No contact orders are similar to protection orders, except it's exactly what it sounds like. It says I can't talk to you. It doesn't say I can't be near you. It doesn't say that I can't send someone else to talk to you. And so they have a little less teeth, but because they're attached to a criminal charge, people are usually likely to comply with it because as it's a condition of their bond, meaning they get to be out of jail, and if they violate the no contact order, their bond is revoked, or it's going to be a basis of their probation. So they've been sentenced, but that's still a provision within that sentence is that they can't have any contact. So sometimes you can have both. You can have a no contact order through a criminal case and say, I still want a civil protection order. That's, I would say, 70% of my cases. So we talked about domestic violence a little bit, but it's attempting or recklessly causing bodily injury or placing the person in fear of the threat or imminent cause of serious harm. It also can be menacing by stalking, and it can be aggravated trespass. Aggravated trespass does not get used a lot. So what is aggravated trespass? Well, you know what trespass is, right? It's coming on the property of another without their permission. Aggravated trespass says that not only are you coming onto the property of another, but it's to commit offensive violence or felony. So like burglary, breaking and entering. It's not used commonly because how do you prove that that was the intent? I've only used it in one case. We prevailed on it, and it was a husband who had been divorced from his wife for 10 years, who just kept showing up at his house. He was homeless, he was an alcoholic, he refused her help, they had kids together, and so he would show up. And usually she would let him sleep on her porch, which was enclosed. But in this particular instance, she realized that this was not helping him, so she told him no. So he broke a window. And that's why it was an aggravated trespass. And so we were able to get a protection order, even though he had never threatened her. He didn't live there anymore. But those are like some of the fine instances in which you really have to know what your law says if you want to get someone a protection order who otherwise deserves it, but doesn't fit under the very limited circumstances that they can acquire one. Menacing by stalking is what it sounds like. Stalking behavior, defined by Ohio, is 2 or more occurrences of behavior that leads the person to feel serious mental distress. Serious, not just regular mental distress, but serious mental distress. And so that's what we were discussing about. It's a higher burden to prove because what is mental distress? I mean, it's different for every person, and it has to be a pattern. And we say a pattern is 2 or more occurrences. There are some states or some districts in Ohio that say 2 or more occurrences is 2 text messages, 2 phone calls. It is, even if I called you 50 times, that's not just one instance. Those are 50 separate incidences. And then some districts say that no, if it all happened on one day, that's 1, which is really hard, right? Because what if I only go crazy once? That doesn't mean you're less likely to reoffend. It just means that you don't fit that criteria. So recklessly would be, for example, this. I'm arguing with you, and I take this bottle, and I'm furious. You said something I don't like. I don't intend to hit you with this bottle, but I'm throwing it near you, and it hits you. That's reckless. It's a disregard for a known or likely fact. So it isn't the intent that I do it. It's that, well, what would I think would happen if I threw something near you? The likelihood would be that it would hit you, right? Especially when I'm angry. And so we've gotten protection orders on that quite a bit, especially between children and their, adult children and their parents. That's strange to say, but I throw a pan at you and it actually strikes you. I push you. My intent isn't to harm you, but I push you and you fall back and you hit the nail, which is in this wall, and you're harmed. That's reckless. So committing an act with respect to a child that would otherwise be abusing a child, child endangerment, or neglect. And so those are harder cases to prove, and I'll discuss why. They're not my favorite, but they're actually the most common in my county. And committing a sexually oriented offense. So that's by statute. Sexually oriented offense is probably something you imagine. Sexual contact, sexual imposition, meaning I'm touching you for the purpose of gratification, sexual gratification. It means straight rape. It means digital penetration. It means encouraging a juvenile to commit an act of prostitution. So these are all things. And now we have, for an organization that we work with, Badass, which is about battling, selfies that are shared between intimate people and then they're later given around to other people. So that's a crime now, but there's an intent. Your intent has to be to cause mental harm to the person. So if I don't know you and I get this picture from your boyfriend and then I share it with someone else, well, there's no intent to harm you because I don't know you. So that statute is really tailored to people who have that intimate relationship because otherwise you can't prove the intent. But those are all ways in which you may be entitled to a sexually oriented offense protection order, which are different than every other protection order. But remember, the relationship is what's important. So if you have a child with the person, you fall under domestic violence. If you've lived with the person within the last 5 years, you fall under domestic violence. If you are a relative by law or by marriage and you've ever lived with each other, you're under domestic violence. So all these protection orders, whether it's a sexually oriented offense, I raped my child, I raped my stepdaughter, would still fall under domestic violence. But say you didn't have that special relationship. That's when we would go to a stalking protection order or a sexually oriented offense protection order. So typically when we say resided with one another, there's a whole bunch of case law that defines what cohabitating means. So it isn't literally what you think, that we moved in, we bought stuff, we bought sheets, we got these nice dishes, we got this couch, we got this big screen TV. It can mean that I spent the night at your house 4 times a month. That's cohabitating. And this has come from criminal law because the nature of relationships is that sometimes people don't full live with each other, but they spend a lot of time with one another. It may even not mean that you have a key to their house, but it's what you would expect in an intimate relationship, that you would occasionally spend the night. Maybe I have a toothbrush over there. Maybe I've had your friends come over to my house. You got some clothes there, even though you still have another residence. So that's cohabitating. We consider it very loosely. So say you never cohabitated. That might be why you would fall under a dating violence protection order or a stalking order. So Ohio becomes the 49th state. I told you this, we're really far behind in getting the dating violence protection order. So dating violence asks people to define a relationship. It's more than a casual acquaintance or business context. It is about the expectation of an intimacy. And so what does that mean? Because that's a lot of jargon. It doesn't mean that you've ever had sex. You don't have to fall under there just because you never had sex. If we held hands, if we kissed, if we presented to the world, whether through social media or our mutual friends, that we were boyfriend and girlfriend, or even because the people in the younger generation don't define themselves as boyfriend and girlfriend, but the suggestion is they have a special relationship, even if they're not exclusive. That might be a way to come under the dating violence protection order. And most commonly what I have seen is that it's been people who have not lived together, of course, though maybe they did spend a few nights a week. But you know, they can choose which one they fall under. You're not excluded to one just because one fits better than the other. And they were all over Instagram, kissing on each other. They would talk on the phone. They would text each other perpetually. And maybe they still never even had sex. That is a dating relationship. But you have to be prepared to talk about it, because if you don't, then you can't get a protection order. So what do you think is the single best way to prove a dating relationship now in today's terms? And think abstract. Facebook. What? Social media, and one that is so common you're taking for granted. Anyone text anyone today? And everyone has every text message they probably ever sent to one person in a conversation. They never deleted it. It just goes back, and as far back as your phone goes. And that's usually the best indicator. Most of my evidentiary hearings include 15 or more pages of text messages. I had one hearing that included 1,000 pages of text messages. People apologizing to text messages. I'm sorry I hit you in your head. I love you. You know, any number of things, because they don't think about it. It becomes evidence. So I screenshot that, we mark it as an exhibit, and I have you read it into evidence. Because you said that before you thought anyone was gonna look at it. So you were probably being truthful in that text message. So text messages are the most common way. And of course, Facebook and Instagram. And Snapchat, occasionally, if people are able to save them.
I have a question.
Yes, please.
Now, a friend of mine, they live in Columbus. The ex-girlfriend of the person that she is now living with is stalking them. What kind of protection could she get for that?
Very good question. So there's 2 answers. Is the girlfriend, the ex-girlfriend, stalking just the new girlfriend, or is she also stalking the ex-boyfriend?
Well, I would say because they're living together now, maybe it's the both of them.
So when you get a protection order in the state of Ohio, you can include household members. And so they dated. Did they ever live together, the ex-boyfriend and the ex-girlfriend? He could get a domestic, oh, okay, perfect. So it doesn't even matter if they live together because they have children together. He could get a domestic violence protection order against the ex-girlfriend and include the new girlfriend on the protection order. Or she can get her own stalking order and include him on the order. But it's going to be easier for him to do it than it is for her because of the special relationship. And she could be a witness at his hearing about why he needs a protection order and why she is going to be a protected party. So when you live with someone who is on a protection order, you yourself can become a part of the protection order. You don't have to have your own. But there are very clever defense attorneys, and I was one, so I can appreciate it, who will argue that you have to show why that person is in danger for them to be on the protection orders. Most judges say, no, she doesn't. She's a household member. She's going to be on there. For orders like stalking, I think that you have to prove a nexus, but most magistrates will just allow the other people to be on the order even if the person has never been subjected to any stalking directly. And that's because if you are crazy enough to stalk one person, chances are you're going to move to the next person whom you think is blocking you from having a relationship with that person. So yeah, I would advise that he get a domestic violence protection order and include the new girlfriend on his order. And everything that's in that protection order as it applies to him will apply to her. And so she could be charged for reaching out to either of them or directing another person to do so or showing up where she works or goes to school, all of it. Okay. But one of the best protection order provisions that I've seen that are not consistent, because strangely, Ohio is one of the weird states where each protection order usually will have the same provisions of things you can't do, but sometimes someone will throw in a little extra one. So stalking protection orders, they have all basically the same protections of a domestic violence protection order, but it has an inclusion of allowing electronic monitoring. So house arrest. So if you can argue to a magistrate that this person has been stalking you and that you deserve a special provision which puts them on electronically monitored house arrest, that can be awarded. Now think about that. Usually you have to have a criminal hearing for that. Civil hearing, burden of proof is far less. I've only heard about it being done in one case. It's never been my case, but the stalking was extremely severe. And I don't know if anyone watched the news this weekend, but there was a gentleman in Hawaii who was stalking a family, I want to say in Utah. He had sent over 500 people to these people's house, thousands of miles away, by posting their address on Craigslist, ordering pizzas, calling plumbers, all sorts of people just showing up at these people's house. Now, it appears that there was something that had happened between the man's wife who was living in Utah and the man in Hawaii that made him want to do this to these people. But 500 people in 1 year had showed up at this couple's house because he posted all this stuff on social media. Now, this is an interesting case because the FBI became involved and it had to extradite him back from Hawaii to Utah to face charges, though he had never set foot in Utah, for criminal stalking because it's that pervasive. I mean, you can really mess with people in terms of social media and just posting addresses. You really can. And so this is one of the most egregious cases that I've ever seen. Usually it doesn't arise to the criminal level, but just think about what this family has been experiencing for an entire year. They actually bought printed signs that say, look, you're probably a victim just like we are. So if you've been sent here, we want you to know we didn't request you. And strangely, the guy was homeless. He didn't have an address. So the U.S. Marshals were looking for him in Hawaii. They found him at a grocery store shopping on Thanksgiving, getting ready to prepare his meal. That level of hatred, I don't think he thought he would be criminally charged. But these people probably were terrified. So romantic or intimate relationship, not a casual acquaintance. You're my best friend, doesn't work. You're my best friend's brother, doesn't really work. Not an ordinary social relationship. It's at the time of the conduct has occurred, were you in a relationship with that person who was an adult? Now this is special because I told you that there are juvenile protection orders for everything on that list, not dating violence, not the way the statute is written. So what is the category of people who are more likely to be in a dating relationship as opposed to a intimate partner relationship? When you're 16 or 17, you don't necessarily live with your boyfriend. Right. So those are the category of people I think need dating violence protection orders just as much as anyone, frankly. But the way the statute is written, it says that you both have to be an adult. Another fine point of law is that, say, though, ma'am, you are far too young to be my mom, but let's say you're my mom, okay? And my boyfriend, who I live with, I don't live with you, is beating me. You can go get a protection order on my behalf. I don't have to do it. You can do it. That's complicated because there are times where the person is not ready to leave the relationship. And so you can't force me to stay away from this person, but this person can criminally be charged for being near me. I won't accept cases like that. If she's not going to come and talk to me, I'm not going to go get a protection order. Now, when I'm a minor, even then sometimes a 16-year-old me may want to do whatever I want to do. It's going to be very hard to stop me from doing it. I won't get a protection order for that person. But when a child has been raped by a relative, those are typically the cases where I'll step in because parent is filing on the child's behalf for harm that they certainly couldn't have consented to. But when it's a dating relationship and the person is above 15, that's a hard one for me to get because your daughter has to testify about her fear. It can't be your fear. It has to be her fear. And so that's a complicated case. And it happens all the time. You're trying to do the best thing you can as a parent. The police won't arrest them. You know this is a toxic relationship, so you go and file on your adult child's behalf or even your 16, 15-year-old kid. I can't do it because there is a special provision within the statute that says that the court can deny a protection order or grant it for the process of justice. And it does not do justice to give a protection order to someone who doesn't want it. Make sense? Okay. So, dating violence. Petitioner must prove that the respondent was in a dating relationship, number one, and number two, that an act of domestic violence occurs. So we talked about what domestic violence is. Reckless, right? Throw something at you, you get hurt. It's an actual harm, I hit you. It's the threat of harm. I'm gonna effing kill you. That's domestic violence. You don't need a pattern of conduct like you do for stalking, right? Stalking is 2 or more incidences. Just one time needs to occur and you can get a dating violence protection order. And it is filed in domestic relations or family court. Stalking is filed in the general division. So what that means is that magistrates and judges who handle criminal cases and like large civil litigation are the people who are hearing stalking cases. And there's no offense to those judges who hear them because I've had some who really take this very seriously, but it takes a domestic relations court to really understand intimate partners. I don't think it consistently does. I have a good magistrate in the 11th district who is amazing at it. But sometimes I feel like there are magistrates who are just like, yeah, one more thing on my docket that I need to handle, right? I'm doing medical malpractice claims, I'm handling criminal cases, and now I'm gonna handle stalking cases.
Well, since you're bringing up the court, have you ever offered training for court personnel about this issue, especially the courts unwittingly, I believe, enable the abuser, because this abuser can have a case where abuser waited until his ex-wife, who was seriously ill, was in the hospital and couldn't respond to get to file in court and get exclusive use of marital assets. The child support from her. She couldn't respond because she's seriously ill. So they're unwittingly cases like that supporting the abuser.
Yeah.
And what have you been able to train any court personnel with regard to that?
What a beautiful and thoughtful question. Occasionally, because it's voluntary, right? So there are mandatory things that magistrates have to do specific to certain subjects. And maybe there's a 3-hour course that they have to take every couple years for this particular type of issue, but it's voluntary. So it matters that their administrative judge is saying, I want you to get all the training you can to be the best magistrate that you can, or that they take that oath to do so. But legal aid is accessible to anyone. And we offer trainings throughout the year. And we have special relationships with all of the courts in our areas that we practice because we want to be able to be a resource to people. And so it largely depends on their willingness to do it. And in the instance that you're explaining, it's horrific, but it's not uncommon, where someone will wait till a person is not able to respond, certainly not able to acquire legal counsel, and take legal actions. They could essentially lie and get exclusive possession. What this woman is speaking about is that in protection orders, particularly domestic violence protection orders, you can be given exclusive possession of a residence. Now, the statute is pretty full because it says that even if your name is not on the lease, if you and the abuser reside together, a magistrate can say, well, he no longer lives there. This is your residence. Now, that doesn't mean that the owner of the property can't institute eviction because you violated the terms of your lease by having someone there who was not you. But even then, there are protections that realistically, if you're prepared to sign a lease, the landlord can modify that lease to put your name on and to remove that person. I've seen that done. But yeah, you can get exclusive possession of a residence. And when you're married, through a domestic violence protection order, you can have a magistrate order that he continue to pay all the bills and he's not even living there. He or she, so I don't want to make gender norms, but most commonly, this is the instance. And so the person is obligated to continue to pay all the bills while you live there, maybe even spousal support. And maybe the court will say, we'll institute a temporary visitation plan or suspend visitation altogether for the other party. And so those hearings are very serious and they're highly contested because you can imagine people will fight over money. If you think you're going to leave me and not get a divorce and have me pay all these bills, I will hire an attorney and we will have a 3-day hearing on a protection order. And those are some of the most common cases that I have. And really the issue is that the court wants you to just file a divorce so they can deal with those issues because that's where they appropriately belong. But in the interim, before you can get there, because divorces do take time, we need to have some temporary order in place. So another reason why this becomes a problem is because when you're dealing with children, if the parties are married, both parties equally have a right to be in these children's lives. So unless you're going to prove an act of, I would say more than neglect, but abuse, the court isn't going to restrict or limit the other person, the abuser, from having access to the children, which is usually going to be another tool that they can use to exploit and victimize you once you've left a relationship. So go ahead.
Sorry,
No, don't apologize.
That, because what if you're in a situation where the child is used as the reason why I'm only contacting her these 15, 20 times a day because I'm trying to get in contact with my child, when really, no, I'm just trying to keep tabs on you or I'm stalking you. I just want to do what I want to do. How do you navigate that?
You guys are asking some great questions. And so there's no simple answer. Here's what I usually do. There are tons of apps out there that have been invented because these intimate issues are never going away. The most common is My Family Wizard. I don't like it as much. There's another one that's free. You pay for My Family Wizard. It's called Close, C-L-O-S-E app. It's free. It allows you to text through this app, but the app is then monitored. So you can download the entire contents of an app to see if a person is violating the terms of a protection order by talking outside of the kids, number one, and whether it's excessive, number two. It allows you to share calendar invites for extracurricular activities, remind people of doctor's appointments, to send money for extracurricular activities. And again, it's all monitored. So what happens is that if the person is like, okay, I want to try to co-parent, which is really common that you're going to believe this person is going to get over you and just co-parent your kids, which sometimes it happens and you're like, yes, and sometimes no. We will say you can talk for limited purposes of exchanges only. The person only has to wait for 15 to 30 minutes for you to arrive at that exchange. If you fail to show, you miss your parenting time. If you're going to be late, you send one text confirming that. Because anything outside of the detailed provisions are a violation of that protection order, and you can file contempt, which is like a quasi-criminal thing. So what I mean by that is contempt says, I gave you a court order. I'm the court. I told you to do something. I want you to follow my order. If you don't do it, there are repercussions for it. There are consequences. So contempt is different than violating a protection order, which is criminal, because there are no charges filed. But a contempt says that the court is going to have a hearing to make you comply. So the first goal of contempt is to get you to comply. So it'll give you a probationary period, let's say 60 days. We're going to come back in 60 days. If she tells me you violated, you're going to go to jail or you're going to pay a fine. So the goal is to gain compliance through probation, not in the sense that you report anywhere, but the person is self-reporting and they proffer some evidence suggesting you didn't comply. And if they didn't, as I said, they can get a fine or they can go to jail or both, and they escalate. They go from 30, 60, 90 to 180 days, depending on the number of violations. I'm going in a protection order case over a year at this point because there have been over 4 violations. He's gone to jail, he violated again. And so, we've given him an opportunity to comply. He hasn't complied, and now the protection order has lapsed. So we filed a motion to renew it because obviously if you're still violating it, you're still a threat. And so this is over a year of this person's life on a protection order. Divorces take less time because this person just can't comply. So we try to set out provisions, and this is part of one of the one of the books that's in there that we're going to talk a little bit about. We can't get too in detail because we'd be here all day, in which you try to lay out specific provisions where the person has no wiggle room to violate it. Because if they can, they certainly will. Sometimes we say, you got to go through a third party. You're just not talking to each other at all. So grandma, your sister, your aunt, she's going to facilitate these exchanges. And if you violate it, then, you know, we try to attempt to change it. But parenting time generally is not one of the ways in which they'll gain compliance, and that's because it harms the kids. So in egregious circumstances, certainly parenting time can be used as a way to gain control. And that's usually through transitional schedules. So what that means is you've been a harm to this person and recklessly acted in a way that would harm a child. So we're going to start out with supervised visitation. And then we're going to do that for 4 weeks. And then we're going to go to supervised, but not at a facility that the state is paying for or that you're paying for, but that the state basically has oversight over. Your mom can act as the supervisor. You can go to grandma's house for 4 hours on a Saturday, and if she says everything goes well, then we'll increase this. But if she says that you come drunk, if you're acting belligerent, you're out of there, and we're going back to supervised visitation. So there are ways in which you gain compliance by letting a person know that the keys are in your hand. You have the ability to control how this is going to progress. And if you can't behave in accordance with that schedule, well, then it's not going to go any further. But I think the best way to do that is to use monitored apps. And that's, like I said, close app, because you can download it, a judge can look at it, and they can see exactly what's going on. Because there's no reason to text me 15 times about a scheduled time that's supposed to start at 2, unless you're running late because of an emergency. Then you send one text and I respond, okay, what do you want to make it up? Should I meet you somewhere else? We don't need 15 text messages for that. So anything outside of that would be a violation of a protection order. Does that make sense? Okay. And so, ma'am, I really try. I hope that we are accessible to train people. But lawyers' job is to I'm sorry to say, but it's to teach. So whether we brief an issue with all the case law and we explain what the statute means, we look at what other cases have done, it's our job to tell the bench what is going on if they're not getting it right. Now, there have been times where, of course, that doesn't happen. So you know what happens? We appeal. That's the best way to teach a judge, is to have another judge tell him no. And sometimes it happens that way. The 11th district happens quite a bit. So as I said, you may file on your own or on someone's behalf. And a parent or adult household member may seek this under the dating and domestic violence protection orders on someone else's behalf, as long as they're a household member generally. But there are other circumstances where people are mentally disabled, but they haven't been probated. My brother is mentally 4 years old. I'm co-guardian. I can handle all his business legally. And sometimes people don't have that probate. They don't know they need to go that route, and that's okay. You can file under a disabled person's behalf if it's going to help or protect them. But Adult Protective Services, believe it or not, has their own special provisions for protection orders. So if you contact them and they open an investigation and they determine that an act of domestic violence happened, or, financial abuse, emotional abuse, the standards that don't apply for most of our cases, they can get a protection order on that basis through the probate court. And that's extraordinary. It's a useful tool to prevent people from being taken care of who are considered elderly, which is generally people above 65 in the state of Ohio. And they're more commonly the people who are financially exploited. Now, ironically, believe it or not, the financial exploitation is not elderly people. People my age are just as likely to be financially bamboozled, tricked into scams, as older people. So that perception is really, changing. So describe your relationship, the length of your relationship for a dating violence protection order, the nature and frequency of contact every day, statements made by the respondent or the respondent's family which would clue us in that we have a special or intimate relationship. And so this is all things that you have to put where otherwise you just check a box under the domestic violence form. We were married, we have children together, we never lived together, we have cohabitated. Those are boxes. But under the dating violence, you got to be prepared to write a narrative. So it can take at least 2 or 3 hours, unfortunately, which is really a reason for people to just say, I don't have time for this. I can't do it. I'm too stressed out. I don't have time to sit down and write this. And so we meaning legal aid, depending on what county you're in, we will offer pre-filing assistance to people request it, but generally we have programs with the courts in which there's already a social worker working with the court that helps people prepare the paperwork for an emergency order. So they'll get a protective order under an imminent harm, and then they'll send an application for us to represent them at a full hearing. And so usually we don't do pre-filing assistance, but other counties where I am do. And in egregious cases where the person maybe has been referred from another, let's say, legal problem in our firm, they'll say, Andrea, can you help this person prepare a protection order? And I will. And I actually prefer that. It's very time consuming. But one of the other things that a good defense attorney will do is that if it's not in your petition, you can't testify to it. You get half a sheet of paper about this much to write a narrative. And then they'll give you more. But if you don't have that person there, like, no, keep writing, we'll just attach it. You're going to write what you think is the most relevant thing right here. And sometimes it's not even relevant. It's just chronologically the thing that happened most recent. So I've had a case just last week. Oh gosh. And I worked on it this morning before I came, where the woman's petition was 4 lines, 4 sentences. And my conversation with her was an hour and a half. So you can imagine we didn't have an hour and a half conversation about 4 lines. And she included none of the most relevant things. And what she's saying, he strangled me, he pulled my hair out, he punched me while the car was in gear, pulled me out on the highway, and was starting to punch me in my stomach. I'm 7 to 9 weeks pregnant, and he only stopped because there was a car coming on the exit ramp, and then he refused to take me home, and he laughed when he saw that he had a chunk of my hair in his hand, and then he took me to Taco Bell to clean up, but wouldn't take me home, and he's put a knife to my throat. None of that was in the protection order. And so now I have to file an amended protection order, which you can do legally, but people don't realize it, to include these things, because a good defense attorney is going to say, she didn't include this, she can't testify to this. Now, sometimes they won't object and you can get it in because by not objecting, you basically agree. But in my county, we have some pretty skilled defense attorneys and they're going to object. And so before you object, let's just amend this pleading because we're going to put all this in here.
Do you think that she did not include that because of her fear?
She's young, which is usually a predictor. Education level is also a predictor. I think she just said, this is the bare minimum I need to write in order to get a protection order, and she was right. But for me, if you are a victim and you don't have criminal charges filed and you want people to know what happened, if you want to have that sense of reclaiming your life, you need to tell your whole story. I don't care if that hearing is 5 hours long, if we got to go chronologically in reverse order about everything that happened so that this is a therapeutic method to get your life back on track, we're going to do it because that's my job. And so I think she just put the bare minimum because she knew she could get it on that. But, you know, I want her to be able to say, because you punching me at 7 weeks pregnant is huge. You pulling.
You all of this.
Yes. And so that's also a skill. People don't want to tell their story over and over again. So my job is not to make them. Okay. So if you wrote in a petition, I'm going to verify what you wrote in the petition. And then I'm going to say, has anything else happened? Has he ever strangled you, pulled a weapon on you? So you're not retelling me things you told other people, because she had never told anybody this. And so the goal is to put them in a position where they're not repeatedly telling, because it's re-traumatizing, but also to say, wow, you survived all of that. And usually they're like, well, I'm the idiot who's saying it's like, hey, but you left now. And it isn't about what you did, it's about what he did. And when you do that, that makes them more willing to talk about it. And it helps you be a better questioner when you get to court. Because if they've said these things to you, you know exactly how to pull that testimony out, where otherwise it wouldn't come out at all. Because the magistrate really isn't, the magistrate certainly can ask questions, but it typically doesn't. So you want to make sure that you have a full understanding of what's going on. Now, the woman in this instance had lost a child because the child's father last year beat that child to death while she was at work. Sorry, it's really emotional. So she's telling me, and I'm saying, so that's what made you file a protection order. She said, when he strangled me while I was pregnant, I just thought, what is he going to be capable of when this child is born? So she's still not even thinking about herself. She's thinking about another individual, but also what makes you keep fighting these relationships? We need to talk about that. No parent wants to lose their child to something that horrific. No one. But that's what made her leave that situation. So by the time we were done, guess how many pages her narrative is now? 4. We went from 4 lines to 4 pages. So length of the relationship, we dated for 6 months, a couple weeks, a couple days. Expectations. Well, I thought we were going to be together a while. I mean, we talked about going on vacation together. I went over to his house for Thanksgiving. You know, things which seem to correlate that there's more than just a casual relationship. And usually sex is an indicator. We don't need to go in depth, but yeah, we had sex. Birthday cards, which people don't really give anymore. Electronic ones. We talk about text messages, letters. I still write my husband love letters because I want my kids to say, oh, they were so gooey and disgusting. But a lot of people don't do that. Social media posts, tattoos, I think are a crazy one, but people get tattoos for crazy reasons now. I've seen them on people, you know, they sent pictures. This is his name. This is his face. Gifts, joint holidays, pets that people share together, acquire together. Lending money. So Cash App is usually a really good indicator. You're sending money back and forth, or PayPal, or whatever, Venmo. Belongings at each other's house. Joint bank accounts is really low on that list because that's really a very traditional thing that people don't do anymore. But it can happen, especially if you're married. But if you're married, we've already established that you have an intimate relationship, right? So we're not under the dating violence statute. Evidence to attach to petition, statements made by respondent about the relationship. So text messages, social media. Statements made to the friends, because we can subpoena those people to come testify. Communications between the parties, those texts again. And conduct to show a relationship. He called me bae. He called me a nickname that no one else would call me by. And here's a funny story about why this nickname came into existence. So all of that is evidence of a special relationship. And so it's minute details that usually build the case. So this is on the form. So this is really blurry, but I'm going to surmise what it says. It's also in your handouts. But this particular dating violence statute has a lot of provisions in it that other protection orders don't have. Like, does the person have a history of protection orders? That's a really good question. Does the person have past indications where they've been arrested for failing to show up to court? Do they have mental health issues? Do they abuse drug and alcohol? All of that is usually a predictor of being in the place that you're at, but it's not on any of the other protection orders. So the dating violence protection orders are the best out there for what we have now, and they have not been actually approved by the Supreme Court. These are drafts that we've been using because the Supreme Court has to approve them and roll out the official ones. I'm hoping that they redo, and apparently they are, the Ohio Supreme Court is going to redo the other protection orders to include this information on it because it's really useful information to building a case. Respondent suicide or homicidal thoughts. Can't tell you the number of cases where I've had people say, she threatened to kill herself because she knew that I would call her back. I would come back. It's a form of abuse, so I want to hear about those. It's also on the lethality assessment, which we're going to discuss. I love it a lot. It's really useful. It may be useful in your everyday life too. Threats to other persons, especially family members. Again, because you can get those people to testify by issuing them a subpoena. Violating court orders, because that tells you that you're at a higher risk for danger if you're willing to violate a court order. Oh, sorry, pregnancy. Your willingness to attack someone who's pregnant puts you higher on the risk, and also because criminally, it escalates an offense to attack someone who's pregnant. So here's what a standard order looks like. This is the dating violence one. You put the petitioner's name, the respondent's name, the clerk of courts will give you a case number, and you can see here that here is where you would add your household members and their dates of birth. So you can include them on the protection order if you put it on your petition. So on an ex parte order, so this is an emergency order issued with only the petitioner and the magistrate present and maybe an advocate or a family friend. So the respondent isn't there because I just walked in the court today because something happened this weekend and I'm afraid. And so I'm asking the court to issue an emergency order. So it will issue an emergency order and set it for hearing within 10 to 14 days in which the respondent would be given notice. He can show up, he or she, and argue why a full protection order isn't needed. But in order to get that emergency order, you have to show a very specific thing. And that's immediate and present danger of domestic violence to yourself and or a household member. Immediate and present. So usually what that means is in correlation to time. I haven't seen this person in 3 years, but when I saw him 3 years ago, he beat me. You probably don't need an emergency order. But you could need a full order, but the question then becomes to the magistrate, why? If you haven't seen him in 3 years, why do you need a protection order? And again, this comes back to your question. Some people utilize protection orders for abusive purposes. And so maybe I'm about to file for divorce, but I haven't seen a person in 3 years, so I'm about to go get this emergency order. Or maybe I heard from his mother that he's about to file for custody in juvenile court, so I'm about to go get this protection order because that's not gonna happen. My kid is not gonna see this person. And that does happen. It does happen. But sometimes little known thought about things is the person went to prison and they're about to get out. And I need this protection order because he is mad and he will show up. So before he does that, there's already going to be a protection order because he's going to go right back to jail if he violates it. And that is a good basis to get a protection order 3 years later, but probably not for an emergency order, but a full order. So you wouldn't have an emergency hearing, you would just get set for a full hearing in 10 to 14 days or even longer, in which you could tell the court why you need this full order. Now, a full order lasts about 5 years. It can be less than that. It's the judge's or magistrate's discretion. It does not exceed 5 years. You can file a motion to renew, but the state of Ohio is very strict about this. For most districts, again, I told you it's not consistent, you have to have a new showing of domestic violence. So he violated the court order, he attacked me, he threatened to attack me, and now I need another order for 5 years. So you literally have to be placed in danger in order to renew your protection order. Massachusetts, I had a custody case very recently wrapped up like 2 weeks ago. The woman had an indefinite protection order. I've never seen that. That means for the life of her, there's always going to be this protection order. And that has due process issues because when you are subject to a protection order, you can't own a firearm. It's a firearm prohibition by federal statute. It's not state statute, but we're obligated to comply with it, so we have to do so. So to me, an indefinite protection order and the harm wasn't severe, and I don't want to rate it, but I mean, we do. But there's an indefinite protection order for this man. He can never own or possess a firearm. It makes it harder to come back in from Canada when you have a protection order. There are a whole obstacle issue. Some positions you can't work in with a protection order. Generally, being in law enforcement isn't a protector because the statute has a provision that allows people who are required to carry a firearm to be allowed to do it in their official duties. So like then you're like, well, how's it very protective if you can carry it and you get to take it home? You just, you're legally allowed to do it in your official capacity. But, so there is a new law that's going forward that there are aggravating factors. So for aggravated homicide, there are factors which are added to a indictment, which means that your penalty enhances, usually means that you're going to get the death penalty. That's a factor that can be considered. That is going to be one of them, that you've been convicted of domestic violence or that you've had a firearm in disregard of a disability. Disability meaning you're not able to own one. And so those are things the law is trying to change because we know that when things get fatal, more recently Aisha's law, the woman who was brutally murdered by her husband who was a judge. And I laugh at that because he had an indefinite suspension. He had not been disbarred. I watched the oral arguments where his attorney argued that he shouldn't be disbarred. His wife didn't want him disbarred. And I'm just thinking like, she didn't want him disbarred because she knew if he got disbarred, he was going to be mad at her and he was going to take it out on her. So it's like, let that man keep working. And he had judges write letters of support for him about why he shouldn't be disbarred. People he sat with on the common pleas court that said they'd never seen him act this way. And I'm like, that's exactly what domestic violence is. You don't act crazy in front of everybody. You act crazy when you're at home. I mean, he beat her horrifically in front of their 2 children in their vehicle. And he said it was because the last matriarch of his family died. But what did I tell you? There is no justification for anything that happens in your life that's going to present a reason for you to behave the way that you behaved. And it tells us that people don't understand that because they want to understand, they want to justify things, but some things just don't have justifications. But it's innately in your nature to be like, well, this is one instance. And I highly doubt that he went from I've never hit you to banging your head 5 times off the steering wheel, biting you in your face, pulling you out on the street, kicking you while you're down, driving off with our kids, telling you I'm gonna commit suicide. And then when he goes to prison for 18 months, gets out in 9 months, within a year of being out, kills you on a court-ordered supervised visitation at the house you're supposed to drop the kid off at. laying in wait in the bushes for you to come. I confront you, drag you in the house, stab you 59 times with the kids present, one of which is disabled, because I didn't want my kids to be subject to sexual abuse. And I know that when parents are single, their kids are more likely to be abused. But they've never been abused before, so it isn't even like logically there's a connection there. You are justifying your behavior. So they're more danger with a stranger who's going to abuse them than with their own dad who beat the crap out of their mother in front of them. So now the Bar Association is reviewing whether they're going to disbar him permanently, but he was just sentenced. He's never getting out. But this is the type of behavior that I'm indicating. It crosses ages, it crosses wealth lines. I've had people tell me, in Youngstown, there's a suburb in Canfield. It's a really elite place. You have a certain level of income to live there generally. I didn't tell anybody because I didn't want people to think bad about me. About you, not your husband. An indicator of abuse has no wealth lines. It's a narcissist. And they don't stop because they reach $200,000 in income every year. And that's what we have to understand. And so the Aisha's law says that if she had had a protection order, this wouldn't happen. She did have a protection order. She had one. So it's a piece of paper. It's not gonna stop you from getting stabbed. It's not gonna stop bullets from flying. At BOSE, we hope that it offers some semblance of protection, but it can't save your life. Not if the person is determined to take it. It set up provisions that now says that you have to be able to get a protective order 24 hours a day. So they will wake a magistrate up at 3:00 in the morning if necessary. But that wouldn't have saved Aisha's life because she already had one. So it's a tough one. I mean, it becomes about training people about what violence is, what it looks like, and stopping them from doing it. You had people who sentence criminals every day fooled by this man because they had never seen him act strangely in front of them. Well, he's not married to you. So the dating violence protection order allows you to split your wireless accounts because people have cell phones where I get on your account. This is the cheapest way for us to resolve or merge our bills. And so now it orders, Verizon, AT&T to split the bill to allow me to accept my own number. And so that I don't have to talk to this person about how we're going to pay this bill. And this has not made it on the other forms, but there is an additional provisions box which you can check and add it, but it requires you to think of it. And if you don't have an attorney there, you don't know to think about that. So these boxes need to be there because the reality today is that usually you do share that account. And so it doesn't say that the cost has to be waived, but I've been able to contact AT&T on a client's behalf and they waive the cost for us because we fax them a protection order. Ultimately, it would fall on the other person. So it's not entirely waived, but it becomes the respondent's responsibility. And when these provisions happen, if a court orders you to do it and you fail to do it, that's contempt. And usually the resolution is that you pay the bill, right? So, I mean, there are ways to do it in other contexts, but the dating violence protection order forms are the only ones that have it literally on the box. The domestic violence ones just recently added a provision for pets, which allocated where they go. I mean, technically they're property, but they're special property, right? Because they can be harmed and they're felonies if you do. So we've started adding them to protection orders to make sure that it's very clearly stated who's getting what animal and who's responsible for it. This is a really good one for dating violence because you know what happens. I'm gonna go on social media and talk about you and tell everybody my side of the things that happen, even though it's not even reality based. And then these people are gonna go under my comments and talk about how you're a bad person and I'm gonna beat your ass when I see you. Dating violence says no. If this happens and you present us with a screenshot of it, you can be held in contempt for doing so. Domestic violence does not have that provision. And that's the most common context we see it, right? We have a child together, she's a horrible mom, I hate her. Things that are not even in semblance or accordance with what actually happened make it on there and everyone wants to be a commentary on it. They think they know. And so then you've actually had people who've been attacked by family members or friends because of something this person put on social media, which was totally not in concert with reality. And so there are First Amendment claims here, but just like I couldn't write on my page, I'm gonna kill this person because that, while it is your First Amendment right, there are consequences for it. You similarly shouldn't be able to not violate a court order by not contacting the person, but then speaking badly about them on social media, even if you didn't tag them. The context meaning we know who you're speaking about. But, those are hard cases to prove, because if I don't put a name, that doesn't mean the magistrate's going to hold the person in contempt. And law enforcement certainly is not going to file criminal charges for it. So we try to be very specific as possible about what you can and cannot do. And usually the magistrates will read the order to the person so they can't say they didn't understand, because I literally told you it's on the record, because there's a recording that I said, do not go on social media and talk about this. Expert testimony. So sometimes in protection orders, I've had actual psychiatrists testify. Usually in one of the major cases that I can think of, it was a sexually oriented offense protection order. So it wasn't a domestic violence protection order, though it could have been. A woman's brother-in-law had been consistently raping her from the time she was 14 years old till the time that I met her at 28. So you might ask yourself how that happens. Here's how. She herself was raped as a child by a neighbor who lived down the street, family friend. He was convicted of rape. He'd raped multiple little girls between the ages of 3 and 9 in the neighborhood, and he was put away for life. She was taken out of her home because there were some suggestions that maybe parents knew at some point, and they allowed it to proceed. She gets returned to her home with her sister, who was just 2 years older than her, at the age of 9 and 11 respectively. And within a year of being returned to the home, her oldest sister was in a relationship with a neighbor who was 4 years older than her. So he's 15 years old. She's 12. And within a year of that relationship, she comes up pregnant. Not wanting the kids to be removed again, they don't report this. I mean, essentially there's some issues, but they don't report it. Now, my client has been diagnosed with PTSD, bipolar disorder, because being a rape victim at such a young age, you can imagine affects that. Also, her grandmother was bipolar, so there's some suggestion that it's genetic. After her nephew, so her sister's first child, is born, he moves into the house, just gradually just stops going back to his parents' house. And they are not old enough to vote yet. He's living there full time, and they've made accommodations for him to live there. And he begins sneaking into her room at night, which is actually just the living room because there's too many people living in the house, and raping her while their grandmother, whose house this was sleeping in the dining room. And so she begins using drugs because she can't cope with this. She doesn't want to report it. She can't tell her parents because she doesn't know how to react, and she loves her sister. At least once her sister catches him, and she blames the sister, saying that she seduced him. Mind you, she's still a minor, so eventually she moves away. She becomes a victim of sex trafficking in Michigan. It's a totally tragic story. I'm not exaggerating. It was one of the hardest stories I worked with. Victim of sex trafficking, catches herpes. She has a child, gets married. That's an abusive relationship. He goes to prison for beating her. She returns back to Ohio. At this point, she's 22 years old. She has a child now. She wants to reconnect with her sister. Her sister's had a few more kids, her nephews and nieces. She briefly lives in her parents' home as she's waiting for her Section 8 to come from Michigan to Ohio. And he starts raping her again. And now she's treated. She's no longer abusing drugs. She's under psychiatric treatment, so she takes psychotropics, which help her sleep. I mean, it basically makes her comatose at night. So he's able to do it totally undetected. She moves out. He steals the key from her when she's visiting her sister, copies it, and breaks into her apartment and rapes her in her apartment with her daughter sleeping in the other room. She catches him and confronts him, and he says, well, I work nights, which she knew, and your house is closer to my house, and I just had to use the bathroom. She catches him one other night, and she pretends to be asleep, and he kind of realizes that she's faking, so he doesn't do anything, and he leaves. Now, she's been seeking psychiatric treatment for 15 years at this point, and her psychiatrist says, you need to go get help. So she reaches out to me. I meet with her. She can't even talk about this for 20 minutes without urinating herself. It's that traumatic for her. Now she's mortified because she's essentially in my chair, incontinence. I don't blame her, but to me it's emotional because I can't imagine surviving a third of what this woman has gone through. The case keeps getting continued for various reasons. He hires an attorney. He has an attorney come to court, and essentially he argues that it can't be true because my client has herpes and he doesn't. So he actually went and got a test to show that he didn't have herpes. What he didn't know is that my client had a hysterectomy, which basically knocks that right out. And I presented her psychiatrist to testify about whether it's possible that this person has made all this up. This is bipolar issue. Testified absolutely not. Not only do I believe it's true, I believe her sister knew and her sister facilitated this and that she would do anything for her sister, so she doesn't want to get her in trouble, but this happened. This is not a lie. She didn't imagine this. And so we get a protection order. Crazy story, right? Hand to God, true story. That's not even the worst ones that we get. The point being, some violence is so inundated that victims are more than likely to repeat violent incidences because they don't know anything better. And we needed a psychiatrist to testify to that. How does she keep letting this happen? How come she didn't report this to the police? She's bipolar, right? So she's sick. She reported it once to a guidance counselor, and do you know she was the person who was removed from the home and kept in a foster home for 2 years. And she couldn't return home because her sister denied it and the brother-in-law denied it. And because she was bipolar, people were like, well, you're mentally unwell, so we can't trust you. And that's what people think. That's the stigma with people with mental health issues. They are more likely to be victimized precisely because no one will believe them. So you need to have a trained professional explain to a magistrate why she didn't report it again, why this keeps happening to her, and that her mental health is not making her create these stories. First time I'd ever had an expert, and it was worth it. Second time I ever had an expert, I had a magistrate who did not want to grant us a contempt. This is the case that I told you has been going on for a year. He forwarded her 2 emails. His email address is his name. Do you think that maybe he did it?
Yeah.
But the magistrate wanted proof. So I hired a computer expert to trace through space these emails from his work account all the way through the server in Antarctica, all the way to Burton, Ohio. And we got a contempt and he was sentenced to 10 days. It shouldn't take this much, but it makes me a litigator, so what can I say? So we talked about allocation of parental rights and responsibilities, which is something that for this group may be very interesting, and we're winding down, so this is the most important part that I want you to take away today. Ohio has an unwed mother statute, which means that mom who birthed child is sole legal residential parent and legal custodian. Father must file in court to establish his parental rights. And until it is done so, mom makes all decisions. There's no court order because the birth certificate and the stretch marks are the only proof that you need to be the legal custodian and residential parent until further order of court. A lot of police don't understand this. So when mom calls and say there is no visitation order, he's never taken me to court, they say, I need proof that you're their legal custodian. There is no proof other than a birth certificate because by statute, until the court says otherwise, you are the legal custodian and residential parent.
Is that true even if she lists his name on the birth certificate?
Even if.
Okay.
So until a court order says dad has acknowledged paternity by signing birth certificate or through DNA testing, and this court has accepted that acknowledgement and establishes the following court order on a entry signed by a magistrate and approved by a judge, a mother is the legal custodian and residential parent. So you can include them on a protective order unless they have gone to court and established and there has been a visitation plan ordered.
Is that the only reason they do that, is so that they can see the kids?
Sometimes. There are very unique circumstances. This is the wild, wild west of my job. I've had parents who have never officially gone to court, but they have worked out a plan for visitation, which is great. You guys agree? I'm happy. but can you put it in writing, sign it, and just file it with the court, and the court will adopt it, and then it's signed, and then and then it's done. But they don't, and I can understand why. You don't know how, it costs money, all very good reasons. But what ends up happening is mom gets a new boyfriend, maybe she gets on drugs, and she is not being the best parent she can be. She's placing these kids in jeopardy, but it's not domestic violence. And so these protection orders are not built for that. The court will grant you an ex parte because they want to prevent a harm that you think is going to occur, but they want to give you time to file in the appropriate court, which is juvenile court. And when you file in juvenile court, they can decide what's in the best interest of these children, because a protection order is not the method to do that. But they don't know that. And frankly, some policies for children's services workers is that they will tell you to go get a protection order, even though they're not lawyers, and legally speaking, you don't have sufficient basis to have one. And so they'll close the case because technically you have a protection order and the imminent harm has been removed. But it's not, because as soon as you go to that full hearing to determine whether your temporary order is going to become a full order, the court is going to dismiss unless you can prove that mom has committed an act of domestic violence. And even then, let me emphasize and stress this, the court will not typically eliminate visitation or parenting time. It will instead place an order on saying you cannot abuse these children. Well, what does that mean? Because Ohio is a corporal punishment law. I can beat my children in order to gain compliance as long as it does not arise to the felonious assault level, which is not simple assault. It means serious physical harm. So you can still see your kids, but you can't feloniously assault them, which you can never do anyway. So the correct order to go get is an emergency ex parte related to custody or visitation from the juvenile court when you're not married. It requires you to sign an affidavit to attest to the things and to testify before the court. And then they set that for a full hearing to determine whether they made the right decision on that temporary order. A guardian ad litem will be appointed so they can investigate, or a CASA worker, and they will talk to parties, they will look at police reports, they'll get medical records, and they'll do all of that. But a protection order is not the appropriate place for this to happen. It can be used as a Band-Aid until you can get to juvenile court. And when I say Band-Aid, I mean a 10-day Band-Aid, but no further than that. You can also get a protection order against a parent, again, if they don't have custody already, or custody has already been terminated or removed. But you can't use it as a stopgap. You should not, because it's very temporary. And again, because the court will not restrict visitation if it's already been previously ordered. Unless you prove domestic violence, and then you're still required to go to court, in juvenile court, to say, hey, this court has determined that domestic violence occurred, but this court that determined domestic violence occurred does not have the right to modify another order of a court. So it needs to go to the proper court to modify their own order. You can't just be creating people to do what you want them to do. You got to go to the right place. Now, when you're married, domestic relations court, which handles protection orders, are the appropriate court, but it's the wrong case number. So when you're married, you want to file in your divorce or file for divorce, or you can initiate a legal action for custody without filing for divorce, but in a domestic relations court if you're married. And the same rules apply. Generally, they will not suspend visitation in a protection order hearing, while they might do it if you come to them on a custody or divorce case. And I say that because divorce cases, the court is required to determine parenting time and legal guardianship of children in a divorce. Required to do it, cannot close the case without it. So you reopen a divorce if it's already happened or if it's going through it, and you determine where these children belong, but a protection order is not the appropriate way to do it. So the Domestic Violence and Allocation of Parental Rights and Responsibilities is the handbook in your book. I just found this. I don't think the Supreme Court is blasting this out. Now, it's for courts. It's a guide for courts to determine where companionship time, parenting time, or shared parenting, and those are all words used interchangeably, but I want to break them down. Shared parenting is what it suggests. It can mean we share parenting equal. It can mean 40-60, 30-70. Shared parenting just means we have the children together. We try to parent together. Companionship says you're the residential parent and the legal custodian, but I have visitation rights. Maybe it's every other weekend, and sometimes shared parenting can look like that. So it's a term of art that they get used interchangeably, but typically when we say companionship, we're just saying we want some type of visitation. You get to make all the legal decisions, the medical decisions, and I get to see them on a set schedule. Shared parenting is usually for people who are married, but it can be for people who are not married if they want fuller time than what you would imagine. And they have best interest factors, which the court has to consider when determining what a parenting plan or visitation plan is going to look like. This guide considers the lethality assessment, which is what we talked about, and it considers the best interest factors to determine what parenting time should look like for the person who has been accused of or convicted of domestic violence. So the more egregious the lethality assessment, meaning the higher it is that they are determining you're lethally dangerous, it is likely, and only in conjunction with danger posed to a child. So think about that. It's an and, it's a 1 and 2. I have to not only be dangerous to the person I'm in a relationship with or previously was in a relationship with, but also inflicted to some degree some harm onto these children. So if the second part is not true, then typically the court will not, on its own, address the dangers of domestic violence on children. So that's where you get creative lawyering. We talked about what it looks like for a child's brain to consistently witness violent episodes, the harm that can be imposed. But you're going to need testimony and expert testimony to talk about that. And you're not going to need to put a child in with a guidance counselor, a therapist, a psychiatrist to be able to talk about what witnessing this violence has done and how it has deteriorated or affected their relationship with the other parent. Because if you are not prepared to do that, and the harm has never been directly inflicted upon a child, the court is going to be reluctant to consider domestic violence as a reason for determining parenting time or legal custodianship. And I don't say that across the board. I'm just telling you what my experience has been. So it makes our job harder. But there also is the factor that we can mold our kids' minds so the things we say about the other parent will shape their relationship with that parent. So if I tell you mom is no good, she's a liar, she was cheating on me, she hates you, her boyfriend is going to hurt you, well, that's not physically harmful, but it does affect the relationship of that parent with that child. And so those are factors to consider. Courts can admonish people not to speak ill about the other parent, but how do you know that that's not occurring? And I haven't said, and don't tell anyone I said this. We rely on mandatory reporters at schools. We rely on the parent to report where they may just look like a picky parent who's just nitpicking because they hate me and they're just trying to destroy my relationship with my child. But really they're trying to keep their relationship with their child intact and truthful. And so the best way to do that, truthfully, is to have a neutral third party who is a psychiatrist, a therapist, or a guidance counselor, or a pediatrician who can denote and mark this stuff, and they can testify about it. Because otherwise, it's he said, she said. So these are best interest factors: parents' wishes, child's interaction, adjustment to home, parties' mental and physical health, continuous and willful denial of parenting time, conviction for enumerated offenses, which are domestic violence, child endangering, abuse, neglect, any one of those, sexually oriented offenses, and establishment of planning residence outside of Ohio. Now, if you're going to grant companionship, you would also consider these factors. So companionship, again, is something less than equal time, but it could be more than every other weekend. It's just a term of art. There's no standard statewide schedule. Each court has their own prepared parenting plan that they execute by default unless parents ask for otherwise. So there's no consistency in it. So you might consider the parent's geographic proximity, because that'll determine whether it's a long distance relationship schedule or, something more closer in proximity. The child's age, health and safety of a child. So special needs child may require a little more hands-on. So they're going to want one party to be legally responsible, and they might want shorter visits because of this child's precarious situation. Willingness to reschedule missed visitation. So as hard as it may be for my clients to hear, you have to seem like the perfect parent. It sucks, but all eyes are on you. If you're the legal custodian and a residential parent, you have a heightened duty, in my opinion, to bend over backwards and appear like the most gracious, appeasing parent to some extent, and allowing the other parent, even if you've had an issue with domestic violence, to parent these children. Because the first time you don't, the court is going to look at you and is not going to see a victim. But if you make every effort to comply with court order visitation, and even when the person missed visitation to allow them to reschedule, you seem like the reasonable person, and that will lend credibility to you when actual major issues occur. And I know that it's not what people want to hear, but I'm just being honest. It has been consistently what I've seen. And so while it may be a tool to exploit and further commit an act of domestic violence against you, at least while the court is viewing over you, you need to appear like it matters that these children have a relationship with their parent and that they form their own opinions about their parent. Not because you won't get them psychiatric help if you believe that it's being teetering and we won't commit an action to have the court reconsider it, but because you want the court to know that I am not the person creating these situations. A manipulator will reveal himself 9 times out of 10 if you just give them enough time to do it. So if shared parenting, you move to the second column. So you consider these other factors in addition to the ones to the right for me. So for the right for you, the left for me, and then the ones above. So the more time the kids are going to spend with the parent, the more best interest factors that the court considers. And you should be looking at this through the lens of the lethality assessment and the type of domestic violence that was committed between the parents and against the children or witnessed by the children. But it has to be an and. So you have to provide a sufficient reason why their parenting time should not be or should be restricted or supervised. And it has to usually be, again, because the act of violence was inflicted upon the kids and the spouse or parent, or they witnessed it. And again, you have to be prepared to talk about what witnessing it does, because just simply saying they witnessed it is not going to be sufficient. So if you want to do something more than shared parenting, maybe you want the person who's been the abuser to be the legal custodian and a residential parent. There's a lot of hoops to jump through. Because what's the implication? That this is going to be another tool for them to commit abuse and to alienate the kids from the parent who is the abused person. And sometimes this has to happen. Why? Because the parties are not married, but mom was really reliant on dad for support. And now that they're separated, she's homeless. She's living in a shelter. She's hopping from couch to couch. She's not stable. And so the court is concerned with the stability of the kids. So mom can't be the residential parent right now. She can't do it. And we need to have these kids stable because predictability and schedules are what helps kids grow and prosper. And so if that happens, the court has to consider all of these best interest factors, including the parent more likely to honor and facilitate time. So is the abuser, who's now the residential parent, going to actually allow mom to see these kids? Is he going to make every excuse for her not to see them? Is he going to make it hard for her? Child support payments, because you know when you're the residential parent, the other party pays child support to you. So mom, who's the abuser, may be under a child support obligation, even if it's minimal, $62 a month. And that includes like Medicare and tax and collection for it. And that sometimes happens. And that's hard too, right? Because you took care of these kids, you did everything for them, and now you're paying child support to the person who kicked you out, and you can't have custody of your kids because of the abuse that you face. Sometimes you find yourself in bad situations and you just got to make the worst of it, and you help the person build themselves up so that that can change. So if convicted of domestic violence or child endangering, and you want to make them the residential parent and or legal custodian, usually you're both, the court is required to think about a shared parenting plan, whether the parties are going to be able to jointly make decisions, which is highly unlikely because they've already had a conviction for assault. Was this a one-time incident or was the violence pervasive? Usually if it was one time, the parents can actually effectively co-parent on a typical schedule. They say, I'm going to leave you, you're going to do you, I'm going to do me. But when I have systematically been abused, you can't make co-parenting decisions because one person's will is always going to succumb over the other. And it's usually the abusers. So the court is designated to think very carefully and particularly about certain roles. Who's going to pick them up from school? Who's going to take them to the doctor? What extracurricular activities do the kids get to be in? Who gets to take them on vacation? Are the parenting times very specific? Are we going to transfer custody or visitation at a supervised facility, even if the visitation isn't occurring there? They have to think about all of this because they want to protect the parent and they want to make sure that these orders are going to be followed. So for a guardian ad litem, you can craft because you know the parties better than the court knows the parties, and they can't agree apparently on what that is going to look like. And so I always task my guardian ad litems of being creative. It isn't a schedule that you found on the court's website if it doesn't make sense for those parties. It may involve that you are creative. You not only have third parties, you have monitoring apps, you do exchanges at police departments or at Walmarts that are open 24 hours, that have surveillance, that they go through a third party, that they go through Hope House, which is like a secured facility. All of that, and that they stagger time, that they use a 24-hour daycare is in one of my cases, so that the parents never have to see each other. They drop the kids off, half an hour, the other parents come to pick them up. And the state pays for the daycare, so it's really no cost to my clients. The state of Ohio is paying for it, but that removes the possibility of the parties interacting, and it allows us to make sure that the visitations are complied with, because the kids are safe. They're in a facility where people are there, they're mandatory reporters, and they have specialized training. Now that's an exaggerated circumstance because typically we're just like, you need to meet at Walmart, you can pick the kid up at your house. But when the violence is so pervasive, you can't do it. You got to think of creative ways to do it. And sometimes that means you go through Job and Family Services to make sure that, parenting time credits are attached to the case so that the parties can use daycare for that purpose. Especially, let's say, when parents work midnights. So the kids have to be dropped off at 5 o'clock in the morning because the other parent is about to receive custody and get the kids ready for school. These are complications that just happen, and you gotta learn how to think creatively and out of the box to deal with them. Unsupervised parenting time, with or without supervised exchanges. So when we talked about the transition schedule, when we were talking about like maybe it's supervised for a couple weeks and then it moves to unsupervised or supervised by a family member, you got to decide what level of supervision, because just because I say supervision, that can mean different things to different people. Am I a supervisor because I'm an adult inside the house, or do I need to have eyes and ears on? You want to have that clearly defined in an order, because without it, that could put kids at risk. Colleague of mine from Trumbull County, mom, strangely, this is very atypical, was the sexual abuser of their daughter. And she had a boyfriend who convinced her to sexually abuse the daughter with him and to record it or to participate in it. And so eventually she did lose custody. I mean, after a long, protracted battle. Dad had gone through multiple states. The boyfriend of mom's had been sentenced. Mom had been convicted but not put in prison. She was on community control, and she still had she still was a parent. Like, he could not get these courts to change custody of this child over. So finally, once he did, during a supervised visitation at an approved supervised facility, mom sexually assaulted the child again and recorded it. And so that's how they were able to find out about it. So while she was on community control, she was eventually convicted again of sexually assaulting it, and she was sending it to the prison for the boyfriend to view. She had had a child with this person, and so they were never not going to be in each other's lives. And she continued to have a relationship with him, even though her child, the court said, as long as you're in a relationship, I can't allow you to have this child because I can't trust you to make good decisions. And so after years of this child being abused, acting out sexually against other kids, threatening to kill herself at 7, being committed to a psychiatric facility for a period of time, horrible dreams, Dad finally got custody. But we had to go through all of this to accomplish this. And eventually he stopped allowing the visitation because if it happened at a supervised facility, what the hell do you think is going to happen when they're alone? So he was held in contempt. And the court held him in contempt. And so we got involved to get the contempt dismissed and to have the girl psychiatrist who testified consistently, this mom should never, ever have any visitation or custody because every time this child goes to see her, if she is not harming her, psychologically, she is thinking that no one cares about her. She's trying to commit suicide. She's failing out of school. She's harming other children. There can be no more. And finally, a court agreed. And the guardian ad litem recommended absolutely no contact until the child was 18 and able to make the decision for herself. But the court was considering allowing still a window for some type of contact, even though the psychiatrist said my opinion will never change. And so my point to you is this: courts will always try to remain some form of contact with an abuser for the child's sake. And that's just the way the law is written. You have to jump through hoops practically to establish why visitation or parenting time should be entirely suspended. And it has to be a very good reason. Systematically being raped by a boyfriend who is now the step parent to you and your parent over years seems like a very good reason. But it took a lot to get there. So it is never as simple as you were abused, your kids saw it, and maybe experienced some abuse, whether recklessly or intentionally, and so they're never going to have to see that parent again. It does not always happen that way. It doesn't. So you have to think of the parenting plan continuum. What makes sense now and what's going to make sense in the future. And now someone that I know very well is a certified custody consultant. So in cases that are highly conflicting and essentially people who have a lot of money, you can contact her night or day and she will make the decision. Betty doesn't want to do gymnastics, but mom says she wants her to. You call this attorney at 5 o'clock in the morning, she will make the decision, and that is the final decision. But you know that the only people who would have access to that are the people who are going to pay you $200 an hour to do that. So for poor people, that ain't going to happen. And so you're going to be a revolving door in court for them to make this decision. And so guardian ad litems have to think of a way, or CASA workers, to avoid that as much as possible. But understanding fully that as children grow up, needs change. And so it is a hard job that I did before I came into this work. It was my favorite part, was being a guardian ad litem. I absolutely loved it. But it is hard work. So pending legislation, Aisha Frazier's Law, we talked a little bit about that. It's progressing still. So it adds the high risk assessment for officers to utilize when coming to domestic disputes. And so they ask a series of questions, which are on the next slide, to determine the abuser's lethality. How likely are they to actually kill this person? And upon that, that goes to a prosecutor who can make a recommendation about bond, whether pressing charges. It can make a recommendation in terms of sentencing compliance and what the person is actually going to be required to do as a condition of probation, so forth. I use it in determining what cases I accept, because if I didn't, I couldn't possibly do all the cases that I do. Last year, I might have 4 contested hearings in one day. That's just not sustainable. You're going to burn out. So now I utilize the lethality assessment because I only take the cases that are most lethal. It's not fair because ideally you would want every person who's a victim of domestic violence to have an advocate or an attorney who can help them. But the resources aren't there, especially when you're cutting public funding by 70%. So it expands the offenses of aggravated murder. So if you've been previously convicted of domestic violence and you commit an act that basically results in murder, that increases the likeliness that you will get aggravating penalties for life or for the death penalty in the state of Ohio. It expands the definition of family and household member and the definition of endangering children to include, and frankly, I've already seen prosecutors do this. If I commit an act of domestic violence against a parent and the child is there, that's child endangering. Because it's acting in a known disregard that perhaps me harming this person will harm that child. It requires localities to establish the domestic violence high-risk teams, which are basically like a collaboration between multiple agencies about which way to direct a case. Is it an alternative dispute? Are we going to do wraparound services for the kids and for the victim, the survivor? What are we going to do to make sure that this doesn't happen again? Do we have access to domestic violence shelters, relocation services? What can we do? 24-hour protection orders, which I told you. It changes the rule of evidence, but here's the part that we live in a world where we think aspirationally. Marcy's Law is an example of this. We implemented great strides and protections for survivors, but it cannot conflict with the Constitution, the federal or the state. And so criminal defendants have certain constitutional rights, and no matter how much you want to legislate them away, in an appellate court, whether it's the Ohio Supreme Court or the Supreme Court of the United States, is always going to modify these current or changes to these laws to make sure that the protections for defendants in the criminal process remain intact. So there are provisions with Marcy's Law that I fully expect to be challenged because I have some concerns, because they conflict with the defendant's rights. And the same thing is going to happen with Aisha's Law, I expect, once it's passed. But it's going through committees now to make sure that they can reconcile it. So this has since been eliminated, but it encouraged prosecutors to adopt a no-drop policy, so they couldn't dismiss or modify domestic violence charges to domestic violence or assault, because domestic violence is not expungible. Assaults are. That's always a motivator for you to plead to an assault rather than a domestic violence, because they're the same level of degree, so it's the same penalty. But what does that encourage the person to do? Reoffend, because they know that it's not going to enhance, because the prior domestic violence charge was dismissed or modified, and because it's expungible. Now, that doesn't mean you can't view behind it for certain positions, but for common positions, it is not viewable to see what the charge was amended from, and what the person originally was convicted of. Domestic violence convictions also prevent you from living in public housing. So when you get elderly and you have to live in an assisted facility, you may not be able to do that.
Once you get there?
Yes, and it's not expungible. Now, some policies are modified, so the federal government is thinking, okay, long term, you've been convicted 60 years ago and now you're living, you can't find public housing, you're homeless. We gotta have some common sense look back periods for this. And so they are trying to make those changes, but as of now, no. I mean, it has to be an internal policy of that agency to only consider certain convictions from a certain length of period of time. And so otherwise, they are bars. They're collateral consequences. That's what we refer to them as a result of being convicted of domestic violence, which is doubly why we're concerned about women or victims who are being charged and convicted when really they are not the abuser. So here's a lethality assessment. You can be certified in assessing this, and once you are certified, you can teach other people. But these are the criteria that I consider when accepting a case. And the number that you answer yes to, the higher you are, the more likely you're going to be murdered. So, and some of them, even if you score low, but you tell me one of these criterion specifically, abuse while pregnant and strangulation are mine factors. So even if you score low, but you tell me that, I will accept your case, because it's super concerning for me. Knowingly inhibiting normal breathing, that's a strangulation case. So strangulation can already be charged as a felonious assault, but a lot of prosecutors don't do it. So now they're going to have a specific law related to strangulation, so you can be charged with that. Increasing penalties for violating the protection order. So some of this already exists. The number of times that you violate it, it enhances the penalty. So you go from a misdemeanor to a felony to a higher degree felony, which means more prison time, depending. Prohibition of discrimination on the basis of sexual orientation. We're pushing that because otherwise you open yourself up to creating tiers of people. Who you love really has no bearing on your access to justice. It shouldn't. Just your individual humanistic rights. creating a standard for sexual violence survivors. I'm on the Mahoning Valley Sexual Assault Response Team, and believe it or not, there is no standard protocol on how to deal with victims who come into the ER having been raped. There's no standard of care. And some hospitals don't even have nurses trained in forensic gathering of evidence, which makes it exceptionally hard to prosecute those cases. And so this bill would change that. And it's crucially important. If you live in a rural area, you're more than likely to be sent out of the state for a forensic exam by a nurse at your own expense. So we've had a patient who had to take a 50-minute ambulance ride, charged her $500, and she was raped. That don't make sense, does it? So we're trying to change ways and methods by having a standard of care for these people when they enter the ER, and that they don't wait for hours at a time, that there's a person trained who's there or who can reasonably be there within a half an hour to come and collect the evidence. Also, the issue you may not think about is if we send you out of state, how do we get our evidence back? That's a chain of evidence problem. Promoting prostitution, we're changing those penalties because the person who is prostituting is the victim. And they used to be charged and the Johns would be let go. It's human trafficking. Doesn't make sense. This bill is about, basically making it illegal for non-therapeutic abortions. Extreme risk protection orders. This is a great bill. It has a huge number of issues. I've read it, it's 50 pages long. Basically, you might be asking, how is it different? It relates purely to guns. And it allows a law enforcement officer to request a protection order on someone's behalf, even though they're not a household member. So if I think this person who I've come to the scene is likely to commit an offense and murder you with a gun, I can request the court to put an extreme violence protection order in place. But then right now as it is, through a domestic violence protection order, through any protection order, you can't legally own a firearm. But how do we check that? You gotta legally have a search warrant to go into people's houses to make sure they don't have a gun. Those protection orders don't allow for that. So my question then is, how does this extreme violence protection order change that? Because you already have a firearm prohibition. It just allows the police to get this instead of you. But if I can't go see that these guns have been turned into the sheriff's department, then you're just still likely to die. So we gotta find ways to deal with that. So human trafficking cases, as it stands, it allows us to charge juveniles with prostituting. And you can't consent to sex as a juvenile, so how can you consent to prostitute?
Right.
So that makes no sense. So this law is in place to try to change it. This record sealing law is great, but the fact that you can be charged in general is what we need to change, because we wouldn't need better record sealing laws if you didn't charge people for things that they legally can't consent to. Marcy's Law, we talked about this. Right to be informed, notified, present, heard. Right to have an advocate present with you. Right to write down your victim impact statement and to read the impact statement. Some courts had this policy that if you wrote it, then you couldn't make a statement before the court. But sometimes I write things because it helps me remember what I'm going to say. So anyway, here's my contact information. And my cards are back there. I have some forms on each type of protection order that we talked about today.